becoming an intervener in the National Energy Board review of the environmental assessment of the Kinder Morgan project is something that should never have happened, because the National Energy Board is uniquely unqualified to conduct environmental reviews. The only reason the environmental review of Kinder Morgan was conducted by the National Energy Board is that the Parliament of Canada under Stephen Harper and the bulldozer approach brought in 2 omnibus budget bills in 2012 that destroyed the scheme of laws that we had had for the protection of navigable waters. That was Bill C-45 in fall of 2012. The integrity of ecosystems to protect fish and fish habitat. That was in spring of 2012 in Bill C-38, and also in Bill C-38, the repeal of the environmental assessment regime. Now, the Environmental Assessment Act was brought in under the Mulroney administration, that wild eco-radical. Clearly, his laws had to go if you were Stephen Harper. The Fisheries Act dates back more than 100 years, as does the Navigable Waters Protection Act, 1882. These laws were not reformed under the previous Prime Minister. There was a crowbar taken to them. This was just brute vandalism. And what happened in the process is that real damage was done to an institution I had previously respected. I wasn't allowed in the room with the panel till the time of final argument. And then I was allowed in the room only when I was presenting. The day before I presented was the expert evidence, or the final argument, rather, of the town of Burnaby, municipality of Burnaby, BC, represented by an old friend of mine, the first executive director of Sierra Legal Defense Fund, Greg McDade, a wonderful Vancouver-based environmental lawyer, and we're old friends. And I emailed Greg and said, I think it would be good for me to hear your final argument. Is that okay with you? And he checked and said, no, I'm only allowed to bring one person in the room with me, and it has to be the mayor. What kind of public hearing is this? That the room has to be empty, and that I can't go in final argument as an intervener to hear the final argument.